Hey everyone, I'm here with my partner Chad Finley. We were having a meeting discussing recent developments in RoundUp. We get together at least weekly, sometimes more, and there's been some rather huge developments in the last few weeks, and we want to get those out to you. Whether you're somebody thinking about letting THL represent you or whether we currently represent you, I think it's important information for you to know, and it can help you either make the decision to go forward or hopefully continue your resolve to help us represent you and hopefully get you a resolution that you're satisfied with. So Chad, why don't you give us an idea what's been going on?
Yeah, so of course, people have heard of the jury verdict that came out of California. That case was called the TorHoerman case. Defendants obviously were upset about the jury verdict, so they appealed to the appellate court.
It's like 80 million, right?
Yeah, it was a big verdict.
Big verdict, yeah.
And so defendants tried to find a way legally to get the case dismissed, which is this thing called preemption. And basically with preemption, what defendants do is they argue, listen, there's some federal statute out there that makes it impossible for us to change our warning label to warn that this could cause cancer. We just couldn't have changed the label. It's impossible for us to do. Therefore, there was nothing we as a company did wrong. We didn't fail to warn because we can't change our warning label. That's their argument. They make that claim a lot of times in pharmaceutical cases, but now they've started also making these kind of preemption defense claims in pesticide and herbicide litigation. So defendants lost at the appellate level as well. And so they appealed to the Supreme Court, and obviously people were a little bit fearful that the Supreme Court would take up and hear this case. Well, the Supreme Court denied their application to hear this case, which means that there is no preemption defense currently on the table for the RoundUp cases, which is great news for all the clients. It means everybody's really back in litigation mode, getting ready for trials. Trials are going to start happening fast and furious again soon, within the year.
So in fairness, though, I talk about that big $80 million verdict. I think it was cut down to like 28 or something like that. Obviously, Monsanto, now owned by Bayer, wasn't happy about that and took it all the way to the Supreme Court and correctly lost. But I also want everyone to know that there's no slam dunks in litigation, right? So not every case is going to go get $80 million or $28 million. There's been a few other trials that have gone the other direction. So the defendants, it's an ebb and flow in these litigations. So it seems like we might need to get them back into a courtroom and get a couple more victories under our belt. Maybe not. Maybe they'll come to the table and offer something reasonable. But that's where it is right now. We are back at it, full go with the Supreme Court decision. And we'll keep you guys posted on what happens. And hopefully you'll give us a chance to help you through the process. Thanks, Chad.
Yep, thank you.